Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today let us learn new topic and new series on labor law, that is the Trade Unions Act 1926. What is trade union? What is the procedure for registration and how is the cancellation of the registration? So let us get into the topic. Prior to the Trade Unions Act 1926, on many occasions, the Association of Workers was held to be illegal and the strikes organized by them were held to be unlawful. Whenever these poor workers agitated against the management, they were surprised by various methods. By 1920s, the British workers were enjoying all the benefits, whereas the Indian workers were being exploited both by the then government and the managements. So there was a hue and cry in the industrial sector, and there comes the final outcome, the Trade Unions Act 1926. Here it prescribes the procedure for registration of the trade unions. The Act provides various immunities and more importantly on civil and criminal liabilities. Though the registration is not mandatory under this Trade Union Act, but registration will have some benefits. They can get, more importantly, they are getting immunity against civil and criminal liabilities. So that is a great benefit. So though these trade unions are earlier meant for the union of workers only, but even the employers can form unions. So let us move to the definition of the trade union. Under section 2 clause H of the Trade Unions Act 1926, the trade union is nothing but any combination whether it is temporary or permanent. And the combination should have formed for some purpose, right? It is performed for the purpose of regulating the relations between the workmen and the employers, workmen and the employers. And also if there is an imposive restrictive conditions on the conduct of any trade or business, and it includes any federation of two or more trade unions also. So these are all in a combination, whether the trade union is a temporary or permanent one, and it should be formed for the purpose of regulating the relations between workmen and workmen, employers and the workmen and the employers. And if there is restrictive conditions and it is also a combination of two or more trade unions. All this combination is nothing but a trade union. So who all can form these trade unions? Tamil Nadu NGO Union versus Register of Trade Unions have decided. This is an important case law which made a decision who can form the trade unions. The Tamil Nadu NGO included among its members the sub-magistrates of the judiciary, tahsildars, office in charges of treasuries and sub-treasuries, officers of the home department of the state. All these persons cannot be recognized as trade union because these are the persons who are the civil servants engaged in sovereign works and legal aspects of the government. All these civil servants who are engaged in the sovereign functions cannot form trade unions. So the registrar of the trade unions have rejected when they formed a union. How is the registration takes place? Section 3 to section 7, we have a number of sections involving how is the registrations process and how is the cancellation process takes place under registration of trade unions. Under this act, registration of trade union is not compulsory, but it has some advantages and benefits like liability or immunity from civil and criminal liabilities. So under section 3 of the act, there is a registrar of trade union at state level where every application has to be made under him. So section 3 refers to the registrar of the trade union. And how is the mode of registration is given under section 4. Any 7 or more members of the trade union, by subscribing their names to the rules of the trade union, may make an application for the registration of trade union. So more importantly, for a trade union we need at least 7 members to form a trade union. And if 7 or more members, they have to subscribe their names to the rules of the trade union. Here more importantly, we should have some rules to the trade union also, and they have to subscribe their names to the rules of the trade union. Application for registration, it deals in section 5. Every application for registration shall be made to the registrar. Who is the registrar? Registrar of the trade union. Okay, has to be made. Every application of the registration should be made to the registrar of the trade union, and along with the application, what we should have? We should have the copy of the rules of the trade union. Copy of the rules of the trade union, and it should also have the information about the names, occupations and addresses of the members making the application. What is the name of the trade union, where is its office, head office, and the titles, names, ages, addresses, occupation of the office bearers of the trade union also. So all this information we should give under the application for registration. If in case of the trade union of workmen, they should also have the names, occupations, addresses, and the address of the place of work and members of the trade union making that application. If any trade union has been in existence for more than 1 year, and if it is not registered, they want to register now, they have to submit the assets and liabilities during that period. So all these things, what are required in the application is they should have certain rules to the trade union, and along with the rules they should submit the applications including names, occupations, addresses of the members, name of the trade union, and addresses of the head office, and addresses of the people of the office bearers, and also in case of trade union of the workmen also where they are working. All this information should be written in the application. And if they are not registered for more than 1 year, they have to also give the statement of their assets and liabilities during that period. So we should have, I already said that we should have some rules of the trade union. These rules of the trade union are mentioned in section 6. Every trade union should have certain rules. That is only the bylaw of the trade union. Unless these rules are submitted to the registration, even though we give an application, if rules of the trade union are not mentioned, then registration will not take place. So what are the rules? The name of the trade union, the objects for which the trade union has been established, the purposes for which the general funds of the trade union can be spent, the manner in which the members of the executive and the office bearers are elected and removed, the payment of the subscription by the members of the trade union, the manner in which the rules shall be amended, varied or rescinded, the conditions under which any member shall be entitled to any benefit, the manner in which the trade union may be dissolved. All these information are under the rules of the trade union, which is mentioned in section 6. So all these rules should be submitted along with the application form. So then only the registration registrar will accept the application. And next, if any other further particulars is asked by the registrar, those are mentioned under section 7. So the registrar may call for further information and may refuse to register the trade union until such information is supplied by the applicant and not from any other source. So the registrar will call. So you have so and so information is not supplied by you. So give that information. Until that further particulars are supplied, I cannot register your trade union. So he will call the applicant. So these are all the things mentioned under section 7. Next comes the registration, which is mentioned under section 8 of the TU Act 1926. When the registrar is satisfied with all the applications and all the things, then he will register. And if the registrar is not taking any action after the application until 3 months, a writ petition can be filed under Article 226, issuing that the registrar has to deal with the application. So then automatically registration will take place. Under section 9 of the Act, registrar shall issue a certificate of registration, which is a conclusive proof that trade union has been duly registered. So section 9 gives information that all the application you have submitted, we have thoroughly examined and we are issuing a certificate of registration. So this is a conclusive proof. And how can we cancel the registration? This is mentioned under section 10. So how can the trade union, if they want to cancel, they can make an application, and if the registrar thinks that you have given this certificate by mistake, or there is a fraud in the application, then he can cancel the registration. and when the trade union cease to exist, then cancellation of registrations takes place. And if the union willfully has contravened any provisions of the act, if they have surpassed any rules and bylaws, then the registration will cancel. When the union has rescinded any rule providing for any matter, if there is a if the union has made some rules that no, we have to close this union, then also the cancellation of registration takes place. All these are binding to the trade union members.